News segment off. We're starting with David Lesch, our legal correspondent. As you know, he's continuing in his series, and today we're talking about debit and credit cards. David, last week we were out there talking about used cars,
That's right.
new cars.
Talking about automobile protections. We're still in the consumer protection statute mode, encompassing the contract law series that I'm talking about. We're going to start today, we're going to really get into some credit card legislation that's already been put into effect the last year or two. But before we do that, we've got to take a step back, talk about some of the acts that have been in place to protect the average user of a credit card. So let's start with the basic Equal Credit Opportunity Act, which really prevents credit card companies from denying you a credit card based on race, religion. They should only be looking at your credit. Now, I know you think, well, that's obvious, but many times in the past, there's been a subtle attempt to avoid giving certain ethnicities or certain genders a particular credit card. That's been done away with, and that's been on the books for a long time now. You also have the Fair Credit Billing Act. That's also been around. That really basically talks on your ability to dispute a charge. Sometimes there's very small print on your credit card statements, and you're not quite sure how to go about it. That act basically tells you that you have to be given notice of the credit card charge that you haven't paid, how much time you have to be able to dispute it, what happens in that scenario. The other one is the Fair Debt Collection Practices Act. That's also been around for a while. That talks about the ability of the credit card companies to collect their debt. Mm-hmm. You understand what I'm talking about when in terms of phone calls that you're getting harassed at work. Sometimes they'll put you on a list where now other people know that you didn't pay your particular credit card. These things are not allowed any longer. They can't call you at work if your employer lets them know, or you let them know that your employer doesn't allow those types of phone calls. They can't call you after 9 o'clock. Talks about harassment, so that's really what's covered in this particular act. Mm-hmm. A couple of years ago, President Obama instituted some legislation, or pushed some legislation through Congress to prevent the average person from ending up in serious credit card debt. To do that, what he really did was he prevented those who were under 21 or the elderly from easily getting credit cards without showing that you have any type of financial resources behind you, which really was a good thing because a lot of the students were carrying credit card debt. The average was at least $4,000 a month on their credit card. So President Obama tried to make it tougher for you to be able to get a credit card. But on the flip side, he made sure that there was transparency with respect to the credit card companies, that if you owed money, you were going to know exactly how much was owed every month, what the interest charges were going to be. If there was an interest charge rate hike, you were going to know how that was going to be affected. And if you were disputing a charge, the average consumer would understand, how do I go about doing this? So let's talk about first getting the credit cards now. Yes, you can't be denied based on race, religion, gender, but at the same time, if you don't show that you have a certain amount of money behind you, you can't just get a credit card. The days in the past when you could just rely on your parents just to get you a credit card, it's not going to work that way anymore. Mm-hmm. Also, if you're older and you do not have a job, you're retired, it's not going to be so easy any longer. Okay, this is where we're trying to avoid credit card debt.
Now, these laws have changed recently.
These laws have changed in the last couple of years because President Obama has pushed forth this legislation based on the individual bankruptcies that have occurred. It's not just in the real estate market, but individual bankruptcies are up as well. It's not just foreclosures. So this was a way of making sure that if you're going to have a credit card, you're going to have the money to be able to pay your credit card debt. What the credit card companies did in the past is that if you made a payment and you had a balance, but the balance really was coupled with other balances within the debt. For instance, you had utility debt, you had debit card debt, credit card debt, all through the same provider. What the credit card company would do is that when they would get a check from you, they would take it and pay back whatever was the highest amount of debt that was owed. But that was tough for the consumer because it meant that the consumer was never getting that particular debt low enough for now that you didn't have to pay finance charges. Well, obviously Congress didn't think that was fair. Make sure that if you're a credit card company, you're going to apply that debt to the lowest balance to get that underneath taken care of. So that was the first thing. The second thing was interest rate hikes. How many times would you see a credit card bill and say, wait a second, what am I? How did they raise my interest rate? I don't understand that, because you didn't realize that they gave you a small little print telling you that your interest rate was going to be hiked. Can't do that any longer. Only in limited circumstances can a credit card company raise your interest rate without you really knowing. The first one is if they give you a new card and it's a promotional card. Let's say for a year you have a credit card for a certain amount of time. If after that year, the credit card company can then raise it up to what the normal credit card rate would be. The promotion's over. That's okay. Another instance, if they give you 45 days written notice telling you what your credit card telling you what your credit card interest rate's going to be. That's another way that they can now raise your interest rate up, but they have to give you the 45 days.
Let me ask you about this issue that we talked about a little bit earlier, the fine print.
Yes.
A lot of people have concerns about the fine print simply because people don't take the time to read it. It's there. Sometimes you can even see commercials, little fine print right there. We can't read it. It's gone real quickly. Who has the liability when it comes to the area of the fine print?
Well, generally, the consumer has to be able to read the contract. But if the print is so small that they don't understand it, then that entire provision is going to be knocked out. So what the legislation has done is it's forced the credit card companies to go beyond the fine print. In other words, you want to institute a change. Let's say you want to lower somebody's the amount of money that they can put on a credit card. Say the balance was, let's say $2,000. They've given you the opportunity to put $2,000 on. Now they want to lower you down to $1,000 based on credit that they've seen or that you haven't been able to pay your finance charges for a while. Well, fine print's not going to be enough. They now have to send you in the mail, okay, a notice telling you that they're going to be lowering the amount that you can put on a charge. And if they do that, they can't do it so that you are now over your limit, so you have to pay interest on the amount above the $1,000. So these are these subtle things that in the past credit card companies were able to do to kind of get away with making extra monies and extra fees. They can't do that anymore. So if there is fine print, but they're making a change, they have to let you know, and the print's not going to be so fine. It's going to be in the form of almost a letter. Now,
closing thoughts.
Okay, they can sue you if you don't pay your bill. All right, and let's say you've disputed it within a certain amount of time. A lot of people come to me and they say, well, can they still go after me? Well, the law in New York, the statute of limitations for any contract is 6 years. So they have 6 years to bring an action against you. So just because they don't do it within 4 or 5, they can still take you to small claims court for that amount above. But now there is a state, let's say I'm going to give you a little bit of a quiz. There is one state in the United States that allows credit card debt or any contract action to be brought for up to 15 years. You want to take a stab at it?
California?
Rhode Island.
Wow.
So 15 years. If you're living in Rhode Island and there's a contract debt, they have 15 years to collect from you. In New York, it's 6 years. 6 years is still a long time. So just because they haven't come after you 3-4 years, they still have time. So people should understand that just because you don't pay your credit card debt and you close the card, and it seems to be there's that they have an action that they can go after you, they still have 6 years. Very important. You should know that.
All right, David Lesch, our legal
Next week,
correspondent.
debit cards.
Next week we talk debit cards.
Debit cards.